Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. Hi everyone, I'm John Khosravi. Welcome to the Immigration Lawyers Podcast, episode 78. This is going to be an annual review of the major immigration law events that happened in 2018 that affect practitioners on their daily lives as immigration lawyers. I'm going to go over some stuff that happened and then go over some thoughts about the future and just recap my own ideas about the practice of immigration law and the business of operating an immigration law firm. You know, when Donald Trump came into power, there were several different areas of immigration that he said he's going to focus on, and actually he touched upon all of them in some way or fashion. So we'll go over a lot of that stuff. One big area that he was having troubles with, and it's interesting because in the news right now it talks a lot about his golf course and how he's essentially violating a lot of H visa categories and using false documentations, I-9 kinds of issues. But he had a big problem with H-1B specialty occupation visas. And I guess I'm jumping right into all of it, but for those who file H-1B cases, I don't do H-1Bs myself. You've been seeing a long delays in the approval of these cases, way past the October 1st start date. That's the regular date. Usually cases are adjudicated before that. Pre-em processing has been shut down for most H-1B kinds of cases, and there's been an increase in RFEs and denials, especially questioning the the specialty occupation nature of the employment that they're doing. So this is a mess that's going on. They've also increased site visits for H-1B cases, and as well as other kinds of cases. I had a site visit for a TN case, surprisingly, and everything went okay, but it was surprising that happened. Now, there's other things they're doing to mess around with the H-1B. One is the changing of the H-1B system, which is going to hit some firms really hard. As it is right now, everyone who wants the H-1B just files the whole case April 1st, hoping for the best. But the way they're talking about changing it is that they're going to have people register for the H-1B, get chosen in a lottery, and if chosen, then filing an application, which is going to seriously hurt some firms who are doing large volume H-1Bs and others who do it little by little. I don't do H-1B, so it's not going to affect my firm in any way, but it's interesting they're moving that system. In one sense, it is kind of better for the client because they don't have to pay for a full H-1B application with the threat that or the fear that it's not going to be even chosen. It's not going to be even chosen in the lottery. So it's a huge waste of resources for them. So it is kind of a good thing for them to pre-choose and pick these out. Now that new system is going to. It looks like it's going to benefit people with master's degrees more than those with bachelor's degrees. They're going to get heads up, but we'll see how it's going to happen. It's not clear if it's going to come in this year, and it being late December right now, early January, if the rules do change, practitioners have to get really quick on what they need to do to register and do all that kind of stuff and do it quickly. I'm guessing it's going to be next year when it gets implemented, especially in light of the government shutdown right now. But with this government, you never know what's going to happen. They also did a really messed up thing is for OPT STEM cases, which kind of touches upon H-1B style cases. A lot of those OPT STEMs will be H-1Bs and maybe perm cases later. Is they changed on the USCIS website about third-party placement when you're on OPT STEM, but it was never officially changed the regulations and no notification was given. And this created a lot of problems for people that were in that window period last summer where this website change happened of whether they're in violation of the status or not. And I had a case myself who was going to adjust status based on a family member who was stuck in this situation. They're able to succeed. But luckily, one of our colleagues sued on this and said you can't just change the website and change laws just like that. And USCIS backed off and corrected the website just as quickly as they changed overnight the website into the negative way. They changed it back, realizing the error of their way. So there's a lot of messed up kind of stuff that's happening. Speaking of the most messed up kind of stuff is the new NTA notice to appear policy that's going to be affecting almost all cases eventually. Right now, I think they're holding off on employment-based cases, but other cases where someone has an adjudication denied, for example, they have an extension of status case pending. Normally, if the case is denied, they should leave the U.S. soon after, and that's that. but they're talking about immediately issuing an NTA for these kind of people, keep them stuck here in the U.S. to hear a court case when they would have left anyway. So it's a real mess how they're doing it. They said they're holding off on employment-based cases, but what happens for the dependents of the employers of the I-129 cases, for example? Do the I-539 dependent, are they subject to the NTA policy, whereas their U.S., or not the U.S., but the primary applicant beneficiary isn't? So it creates a lot of hassle. I haven't seen this happening, but these kind of cases haven't come up in my practice, and I've heard others have it. But it's a really messed up situation. Along with that is student visas, F, M, and J kind of cases. The duration of status protection that kept people from accumulating unlawful presence has been done away with since I think August or September, and that mountain's going to crash and fall on a lot of people coming out on February time when the 180-day mark hits of unlawful presence, and people are going to start being subject to the 3-year bar and eventually the 10-year bar. And a lot of times they might accidentally fall out of status, not even know it, because maybe the DSO, the designated school official, made a mistake, or sometimes CVIS is messed up, or some sort of paperwork issue happened. There's a glitch. Now they could be due reinstatement and try to fix it, but it becomes a big panic moment for these students, whether it could be fixed or not. Some schools are not very helpful or don't want to help in these kind of situations. So it's pretty messed up situation. Right now we're dealing with the lapse in federal funding for a lot of the government. It's a shutdown right now. In some sense, USCIS isn't affected because it's a fee-based agency as well as consular processing. But they work a lot with other agencies in the government, so there are slowdowns, and it does affect it in some way or another, especially when it comes to administrative processing, background checks, for example, if you need the FBI involved or something like that. So that's a really messed up situation. I have colleagues right now who have EB-5 cases that are had their interview and they're waiting for the visa to be issued based on a regional center case, and embassies have been saying that they're not going to issue the visa because along with the lack of funding and the signing of the budget bill, the regional center program authorization wasn't continued, so they can't issue it. I was under the mistaken belief, I guess, that if once you start a case, it's okay, there's no new cases, but apparently these cases are halted as well until the situation picks back up again. So it's a very scary, messed up situation if you invested all this money, you spent all this time with the EB-5 program, and then you don't know what's going on. Which just goes to show the EB-5 program is just not a good program. The way it's designed and executed on all aspects of it is so much of a risk that when clients and consultations I have on it, I just tell them it's super risky. If you don't mind losing out on the money because of a bad investment, or mind the government changing their mind and doing this, and you're so rich where $500,000 doesn't affect you and you don't care, then do it. But other than that, it's a super risky program. And if they're going to do direct investment, $500,000 or $1 million is not enough. They need to invest 2 or 3 or 4 times that to make sure that the investment is going to stay alive and they can hire enough people. So it's just a headache when it comes to those kind of stuff. On the semi-plus side, they've made it so that the medicals, the I-693 medical for adjustment of status cases, are going to be valid for 2 years now if the doctor signs the application within 60 days of filing of the I-485 petition, or if the I-485 petition is submitted after us, for example, during the interview process. The way they wrote that was confusing, and I misunderstood it originally, but I think as long as you submit the medical within 2 months, or get the medical signed within 2 months of filing or after, then it's valid for 2 years. And I think this also applies to previous cases that were submitted previous to this new memo coming up. They'll be valid for 2 years as well. So that was interesting. Another thing is, people who have adjustment of status case pending, if they want to travel, they have to get advance parole. Because adjudications are taking longer, especially for employment-based cases, the initial advance parole is going to be near expiring, and the people may need to travel. So what you have to do is then ask for a renewal, a new advance parole permission. I recently got those, and it was issued for 2 years with the employment authorization, surprisingly. But there was a recent policy where they said that if you have advance parole and then you're traveling on it, but then you have a renewal advance parole pending, because you're outside the U.S., that renewal is automatically going to be invalidated, which was such a stupid and messed up thing. Just the fact that you need to get employment authorization and advance parole when you file for adjustment of status is stupid in my opinion. They should automatically be there. But they came back and they finally said that if you have advance parole, you're traveling, and you file for a renewal advance parole, the travel on the previous advance parole is not going to invalidate the renewal application. It shouldn't be a problem. And it's listed right now on the I-131 website for USCIS explaining that this is the case. So that was a positive. With all the messed up stuff that's happening, even that was messed up, they would even invalidate in the first place, but at least that's fixed. Now, the really messed up situation where the travel ban still exists, I just read a case where a Yemeni's mother wanted to get a visa to come to visit their U.S. citizen child, like a really small child who had some sort of genetic brain disorder and was dying. And it wasn't until lawsuits happened, the news got involved for a whole year, they finally issued a visa where the mother was able to come to the U.S. just to watch their child die and take them to the grave. So it's a really messed up situation with the travel bans working. It's really hostile and really, I don't think, provides any protection for the U.S. other than developing animosity. I was in Las Vegas last week, and in the elevator, I met an Iranian woman who had a child, and I was with my kid, and we started talking. My wife started talking with her, and they were talking about second kids and that. And the Iranian woman said, I'd like to have a second child, but I'd like my mother to come and see the child and be there. With the travel ban, my mother can't come. So right now, we're holding off on having a second child until the travel ban situation gets cleared up, which is an unknown. It's been going on for a year or two now. Who knows how long, much longer it's going to go. So these travel ban stuff are affecting people's lives on a drastic, hardcore basis. Even U.S. citizens, for example, their timing of when they're going to have children, how old they're going to be, what effect the age of a mother has as they get older, waiting for a travel ban to end, for having the kid. All these kind of stuff, it's really disrupting people's personal life for very stupid reasons. There really is no security threat. I can say that easily. The U.S. embassies are very good at detecting this stuff if they want to, and if they get the okay to do it. All the so-called terrorist activities that have been coming from non-travel ban countries, Saudi Arabia, Pakistan, and these people have had no administrative processing before entry, as opposed to Iranians who go through sometimes a year or 2 years of administrative processing before entry. So there's a lot of politics involved, somewhat conspiracy involved, but I see on a daily basis how people's lives are disrupted. Good people, honest people, Americans that really don't deserve it. So it's a really messed up situation. And along with that, the corollary is the situation at the border. This border wall they want to create is just is a sign of decline of the empire, that you need to create a border wall, frankly. Reminds me of China when their Great Wall, which was an indicator of decline of their great empire. But right now, people are dying at the border. People are stuck. President Trump's trying to change the rules of how a person can attain asylum. For example, they tried to change it so that if someone enters unlawfully at a certain point, after a certain date, they can't file for asylum. So luckily, the courts have ruled against that. They said that's ridiculous. You can't just change the rules like that. Apparently, U.S. is making some sort of agreement where asylees or asylee applicants can wait in Mexico while the case is adjudicated, which doesn't make much sense to me how that's going to work out, but we'll see if that's the case. So it's a weird situation. And along with that, we for better or worse, got rid of Jeff Sessions, the Attorney General, or President Trump got rid of him. And the new guy, Whitaker, is there. It's not clear what kind of person he's going to be. It doesn't seem like he's going to be much different from Jeff Sessions. He has been referring BIA cases to himself, which is a really nasty thing. A way to do it, just to make laws like this. And there is some pushback finally happening from IJ's immigration judges who are really bearing a brunt of a lot of this nasty immigration court events, to say we need independence. We need an independent judiciary for immigration courts. ICE and the judges can't all be on one side attacking the immigrant. There needs to be independent judiciary that can make their own decisions at their own pace, based on the proper interpretation of law, not someone forcing them to make decisions or accusing them from the case when they don't like it, when it comes to the Attorney General accusing them. So hopefully that is the case, and we can put more pressure on that happening. Nowadays there's really no prosecutorial discretion, no real administrative closure on those kind of cases. They're taking away different classes of asylum claims from asylum applicants. And they just issued a memo where they make it kind of a duty of the OIR to do disciplinary hearings for what they believe are issues with immigration lawyers making mistakes. So they're really putting the pressure on the judges, and then putting pressure on the immigration attorneys, and it's a very difficult process to be in. Already as it is, immigration field is very difficult. There are bad immigration attorneys, special removal-based immigration attorneys, but frankly all immigration attorneys, a lot of bad ones. But there's honest mistakes that can happen, and so, to push this kind of disciplinary hearings, it's really an attack on the immigration bar. That's something we need to work our way, as a group, work a way to push back on. Another way the administration is affecting the immigration situation is they're really pushing denaturalization, creating denaturalization groups, officers to look over cases and review them to take away naturalized citizens' citizenship. And they're also reviewing the work of USCIS officers, creating a separate agency, so they have a person look over their shoulder. So it creates another level of even policing themselves. And this is really going to bite themselves back in the butt themselves, because they're putting pressure on their own officers. And eventually that creates a point where they're going to either leave. Unfortunately, the good ones leave, and what's left isn't the best quality. But they then feel the pressure, and then they push back themselves as well. For example, with the budget situation and the shutdown of the government, a lot of employees are not going to get paid and all this kind of stuff. They're creating more animosity towards their superiors. So it's an internal struggle, and civil war is going to happen when they're doing this, burning people on both sides. But I guess that's just the nature of the system we're going through right now. USCIS has become more difficult to deal with recently with the pilot programs where they're shutting down info passes. For example, Los Angeles District 23 is one of them, where you can't just show up or do an info pass nowadays. You have to call the customer service line, and that headache. I had a call a couple weeks ago where I was on hold for like 5 minutes, and they said, call back. Or I was on hold for like 30 minutes, and when I finally got a hold of somebody, they said we're too busy to take calls, so they call back tomorrow. And I was like, okay, so it's a huge waste of time just to get an info pass appointment. Who knows what kind of help they're going to give at the info pass appointment. They've also stopped the email case assistance programs for service centers where there are problems. You can email a service center to kind of fix the case. And I didn't really use it too often because I didn't see them helping us too much on it, but they shut down that program. One quick note about the courts making a good decision is the Ninth Circuit had a ruling that says the government bears the burden of determining whether someone's not a citizen if they were, their whole lives put out as a citizen, they had a passport. Because recently, they used to happen during Obama's time, but more and more, they've been finding problems with people's passports who were born near the border, saying that the initial claim to U.S. citizenship was based on, for example, a midwife's affidavit attestation as being a witness. But in fact, these people might have been born in Mexico, for example, and not in the U.S., and the applicant bears the burden to prove this. And in this case, they said that if somebody's been a U.S. citizen and passed for their whole lives, it's up to the government to prove that they're not. Now, in some cases, the government somehow finds Mexican birth certificates for these people to prove it. But in other cases where they can't, they need to prove that the person's not a citizen before they could denaturalize them. Not denaturalize, but take away their birthright citizenship. Now, what's going on next year in the immigration system? Well, as I spoke about earlier, the H-1B is going to be changed up one way or another. What's going to happen with H-4 work permits? Are they going to take those away or not? We've been hearing about it so much on and off about these lawsuits, but who knows what's going to happen. The Department of Labor has stated that they're going to start pursuing fraud. So on the perm stuff and H-1B stuff, they've already been cracking down, trying to make it harder with the specialty occupation definition, all that. The Department of Labor is going to get involved in looking at that too. They've also they've talked about cracking down on J-1s, which are used as work permits and work authorization in some cases, to try to stop that as well. The big things one is what's going to happen with what they call chain migration. Are they going to crack down on family-based immigration or not? Are they going to change the employment-based system? But a big one that we're going to hear about soon is the ground of admissibility based on public charge. What are going to be the new standards? If someone gets health care, someone's bankruptcy or credit report, what are the I-864P standards going to be? Are they going to raise that above 125%? What about cases that are currently pending? Is that going to be affected? What about asset-based adjustment of status? FAA supports are using the intended immigrants. There's so many parts to this and so many ways that this could go down. It's such a complex system. So we're waiting to see how that's going to work and how that's going to affect our clients. So that's the legal stuff that's happening with the government, and most of it is just bad news. Unfortunately, it's a kind of a depressing year. I remember in February, and I'll talk about this podcast, that's when I was getting hit hard by a lot of dumb RFEs, and all those RFE cases were approved. And they were all about like I-864s, asking for stuff that wasn't required for before, asking for stuff that I already sent them. So it was like a really big headache. It caused a lot of worry for me. But they all worked out good, but I really expect the same to happen. And so it's very important just to, before sending the application, make sure all your ducks are in a row, because nowadays the consequences of an error are very drastic, where a person can get denied, then they issue an NTA, then they go to court, and there's no administrative closure to fix the issue or prosecutor discretion. So it's like a domino effect that just falls, and it hits people. So you got to be very careful about keeping the situation proper from the beginning, and delaying filing of the case until you're fully ready to do it. It's going to annoy a lot of clients, and I've had clients get very frustrated, but I tell them, until we have all the documentation, all the answers, we shouldn't move it forward, because that's a recipe for disaster under this current administration. Now, some recommendations for the new year, 2019. Join as many immigration groups as you can, professional groups. There's a lot of online groups, especially on Facebook now. You can join where people ask a lot of questions. Visit those, join those, read them. If you want to join them, don't know which they are, email me and send me your Facebook group, and I'll try to add you to them. They're really good resources for reading other people's questions and answers and learning, as well as AILA-related groups, for example, the listservs and stuff. Those are really interesting groups. There's so many more and more of them that they're making that they're good to do. Also, continue going to local AILA events and immigration bar events. It's a great way to meet fellow practitioners, learn a lot. One thing that the LA County Bar Association has, the immigration group, is they have different dinners across the city for small groups to sit, and we eat dinner and ask each other questions and stuff. I learn a lot from those groups and make a lot of friendships. So it's a fun time. Los Angeles is a great place for the camaraderie of immigration attorneys. I recently talked to a couple of attorneys in other jurisdictions, and they're amazed of how friendly LA is. They're I don't want to name the cities they're on, but some major cities. They said like their fellow immigration attorneys look at them as competitors and as enemies, and they do everything they can to hide information from them, which I was surprised because in Los Angeles the situation is so friendly. There are some immigration I run into that look at me like I'm like an enemy or competitor, which is kind of weird. But most of the people that I practice immigation law with, my colleagues here in Los Angeles, aren't like that. So if you are in a jurisdiction that's friendly, definitely try to get friends with them and share information. Also, keep studying as much as possible. I try to do as much as I can in this podcast. But read the statutes, the adjudicator's field manual, the foreign affairs manual. Just read it for fun. There's all these tidbits of information that come, and it can be really positive for your clients in the future when you know certain pieces of information that can help them out. Here at the Immigration Lawyers Podcast and the website that I'm hosting on, immigrationlawyerstoolbox.com, I constantly update any news regarding immigration, and I have a continuing education material that I'm putting out. For example, I have a new program where I studying L1 AEO cases and providing synopsis of the various cases. It takes tens of hours to do these every month, but I put them all in one place and in a succinct way relay the information to people, to practitioners, so they can become better L1 attorneys. Also, one point to do, especially with the changes like in California about retainer fees and how flat fees should work, is keep track of all your time and all your costs when it comes to cases. I know it's annoying for immigration lawyers because we do flat rate, but try to keep exact matching time of how much time you're spending on a case. In one sense, in case you need to give money back, you'll know how much time you spent, and you could more easily return those fees. But more importantly for me is that by tracking the time, I know exactly how much a case costs, because sometimes, and everyone says, oh, my head, I keep it, I know this and that, and I have an idea. But in reality, when you write down the time, sometimes something you think took an hour really took 10 minutes, and sometimes something you think takes 10 minutes really takes an hour. So it's really good to have an exact idea of how much these things are taking, and knowing your hourly, and then assigning value to each case based on that. And you might see some cases that you thought were easy money were actually losing money for you, and some cases that were losing money were actually gaining money for you. So it's very important to keep track of this stuff. Now, I mentioned the Immigration Lawyers Toolbox. One thing I'm starting to do on the Immigration Lawyers Toolbox is to add a classifieds page, a job listing page. There'll be more classifieds later as I grow it, but for now, it's a job listings page that I've really set just for Los Angeles for now. So if there's immigration attorneys who are listening to this, especially if you're in Los Angeles or you want to move to Los Angeles markets, if you go to immigrationlawyerstoolbox.com, there's a jobs posting page where it lists current availabilities for openings. And, there are a lot of job openings for immigration lawyers available, especially people who have experience in their employment-based or removal-based proceedings. And so if you go there, there's 6 or 7 firms that are hiring right now. There's a lot more, but I'm going to slowly add that, and then add different cities, Northern California, more in Southern California, New York, Florida, and just expand that. And they eventually have a classifieds portion where if you're selling your Kurz van or something like that, you could post it there, or at least send me the information, and I would post it on the site. Finally, this year was kind of a crazy year in Los Angeles. There was a big shooting in Thousand Oaks, and immediately afterwards, there was a big fire in major parts of the county, and the next county over in Ventura. It was really burning down tons of houses. Also in Northern California, burned down a lot of places. And this year, I became an adjunct professor of immigration law at Pepperdine Law School, and I couldn't go to school and teach for 2 weeks because they had shut down the campus because of fear of fires. When campus reopened and I finally went back to campus, I saw the law school there literally had the fires come up to the walls. I mean, there was a parking lot there, and there's a law school, and there's burnt trees right next to the law school in a circle. So they were really fighting for their lives of keeping Pepperdine Law School alive, and it really showed the fragility of the whole situation. Now, Pepperdine is in a natural environment that has next to the mountains. These fires do happen, and mudslides and all that kind of stuff. But to really see burnt trees and burnt ground right next to a place where it's a place of employment that I go on a regular basis. It was kind of nasty. It just shows how fragile life is, how quickly things could change. So it's somewhat nihilistic, I think, but try to just enjoy the day by day. Who knows what's going to happen tomorrow? So just I'm going to leave you all with that. Try to enjoy your time here, be with your family, try to take it easy. But at the same time, you got to hustle and make money and have a long-term plan to keep your practice alive so you can support yourself and continue doing what you're doing. It's such a wonderful practice area to be in. Hopefully, next year will be a better year, and our resiliency will show by challenging these ridiculous decisions by those in power with regards to the most simplest and most fruitful immigration-based cases that we have to deal with. But other than that, I'll probably do a monthly episode, regular episode of interviews as regular, but I wanted to do this special year review and recap of things that have been going on in the immigration field. If you have any questions or wanted to contact me, please email me at info@jqqlaw.com. If you're listening on iTunes, please leave a 5-star review. And if you're listening on YouTube, mark it as a thumbs up as well. And with that, I bid you adieu. Have a good one, guys. Have a great 2019. Bye-bye.